Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those here in Carson City, as well as anyone there in Las Vegas, and of course, people watching online through Nellis or our legislative YouTube. With that, Secretary, please take the roll.
Assemblywoman Bilberry Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch. Assemblywoman Marzola.
Here.
Assemblywoman Mosca. Assemblywoman Newby. Assemblyman Ortlicker. Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. Chair Miller.
Here, and please mark Assemblywoman Newby present when she arrives. Just a few friendly reminders. Please, everyone, turn off your electronic devices, anything that can make noise during the hearing. Also, please make sure that as you're getting your materials ready for any scheduled hearings, that you make sure that your stuff is in to our committee manager before 12 noon the day before. With that, we'll go ahead and get started. We do have two bills today, and we are actually going to take them out of order. So we will first hear Assembly Bill 408. Assembly Bill 408 is presented by, or sponsored by Assemblywoman Brown May, and there will be a number of co-presenters that I will let the Assemblywoman introduce. And this measure revises provisions related to reckless driving. Now, our Assemblywoman is going to kick it off and then rush back to her committee for some much-needed work. So with that, the hearing is open, and it's all yours, Assemblywoman.
Thank you. Thanks for the opportunity to present Assembly Bill 408. Thank you, Chair, Vice Chair, members of the committee for having us here today. For the record, my name is Tracy Brown May. I am the Assemblywoman currently representing Assembly District 42 in Clark County. Assembly Bill 408 revises the provisions relating to reckless driving, and this bill is the result of many conversations throughout the interim and is meant to address safety on our roads and in our communities. From my home, late at night, I can hear cars and motorcycles racing up and down Spring Mountain. You see burning rubber and you smell it in our neighborhood. So you know there is some reckless or unsafe driving that's happening in our neighborhoods. And when I started to ask questions in conversations, I found that is referred to as trick driving. And trick driving is a growing concern in many of our communities. And as I started to research this bill, found that we had a great interest from Reno and Sparks and Henderson and Las Vegas and Clark County. And so there are a number of provisions that are being put into place in order to decrease trick driving. But one of them is this provision that we're going to talk about today. So this morning, you're going to hear from the experts that work on this issue daily. I have had the opportunity to view video that has been supplied from some of our traffic cameras about the instances that actually happen and the injuries that result from bystanders or other people that are just watching these activities. This morning, I'm going to introduce you to Ashley Garza Kennedy with Clark County, who's been doing a lot of work on this bill, as well as our traffic intervention officer, Mike Teal, who is in Las Vegas, and the team from the Las Vegas Metropolitan Police Department. And then Metro is here as well. We have plenty of people that are on hand to help walk through this issue to answer all of your questions. You're probably also going to hear from the public defenders later today, and we continue to work on these conversations to make sure that our fines are not onerous as we tow vehicle and as we talk about tow without arrest. And so it's about increasing the safety on our streets while we're stopping the behavior from happening. And so with that, I'm going to turn this over to Ashley. I want to thank you the opportunity to present this bill. As Chair said, I'm going to go run up to a work session in the Ways and Means Committee. Thank you.
Thank you, Assemblywoman. Hello, Madam Chair and members of the committee. My name is Ashley Garza Kennedy, representing Clark County, and I want to thank the Assemblywoman for her willingness to carry this bill. Clark County has seen a rise in trick driving displays across the valley, and I know my colleagues here in Reno can also attest to the same challenges. One of our commissioners, Marilyn Kirkpatrick, attended a ride-along last year and witnessed firsthand the gravity of these displays and the impact they have on our roadways and our traffic safety. Our board felt strongly that we needed more mechanisms to prevent trick driving. For clarification purposes, trick driving is defined in NRS 484B.463 and means using a vehicle to perform tricks, stunts, or other maneuvers on a public highway upon which traffic has been diverted, slowed, impeded, or blocked. Before we walk through the provisions of the bill, I would like to pass the presentation over to Officer Mike Teal and Lieutenant Daryl Rhodes, who are joining us from Las Vegas in Grant Sawyer. Officer Teal and Lieutenant Rhodes are with the Traffic Bureau of the Las Vegas Metropolitan Police Department, and I would like them to talk about their experiences in the community. I'll pass it to you, gentlemen down south. Thank you.
Hello, Chair Miller, my name and members of the committee. My name is Mike Teal. That's Mikethiele, and I am the Traffic Intervention Officer with the Las Vegas Metropolitan Police Department, LVMPD. I am joined here today with Lieutenant Daryl Rhodes and Andrew Bennett, the Director of Clark County Office of Traffic Safety and the Chairman of the Nevada Advisory Committee on Traffic Safety. At the beginning of this pandemic, we quickly saw a deadly rise in reckless driving, trick driving, and speed contests on our public roadways. As a result, LVMPD formed a specific team to identify and apprehend the drivers participating in these prohibited activities. These activities draw a very large crowd. These aren't kids just there to have fun. We have recovered several firearms, at least 4 just in this last week. We have had people hanging outside the windows of their vehicles. Their driver's door is open and they're holding it while they are performing their tricks. This is a danger to the public and the crowd that is gathered. It commonly results in injuries. We had a double fatal at Jones and Flamingo from 2 vehicles that were racing on our streets and endangering the public. I want to thank Assemblywoman Brown May for sponsoring this legislation and allowing us to present to the committee. I will now pass the presentation back to Ms. Kennedy in Carson City, who will go through the provisions of this bill.
Thank you, Officer Teal. So I'll go through the provisions of the bill. First, starting with Section 1, it expands the circumstances in which a law enforcement officer may remove a vehicle from a highway to include if someone has been issued a citation for reckless driving. Currently, the options that we have to address reckless driving include a verbal warning, a written warning, a misdemeanor traffic citation, or arrest in which the car will be impounded. We believe that allowing us to issue a citation and tow a vehicle will allow us to remove the vehicle from the road, but avoid unnecessarily arresting the driver. We have seen circumstances where a traffic citation is issued and the driver continues to participate in trick driving later that evening. Section 2, subsection 1D and E expands the definition of what constitutes reckless driving as defined in NRS 484B.653 to include premises the public has access to. We have seen a rise in instances where trick driving is taking place on privately owned roads or warehouses, which has limited our enforcement capabilities. This language will allow us to stop trick driving displays in areas that may be on private property but is publicly accessible. Finally, Section 3, subsection 3 relates to circumstances in which a vehicle can be released after being connected to a tow car but not yet taken to a tow lot or garage. This section ensures that someone cannot have their car released under these circumstances if the tow is requested by law enforcement. That concludes the presentation and the bill, and we're happy to stand for questions.
Thank you for your presentation. I'll just give members a moment to collect their questions, if they have any questions. First question will be from Assemblywoman Cohen.
Thank you, Chair. If it's okay if I can have a couple questions. I've got one about the bill and then just,
Let's start with 2 2 questions, please.
okay, thank you. Okay, thank you for the presentation. And so my first question isn't about the bill. It's about, we've dealt with trick driving before in this committee, and I seem to remember that there was something that Metro was doing with having some nights where they had events so that people could come and do trick driving at the events and do or drag racing, stuff like that. Is that still happening, and did that help?
Ashley Kennedy, for the record, with Clark County. I will pass that over to our Metro officers down south.
Lieutenant Darrell Rhodes, for the record. There are events that continue to happen out at the Speedway, allowing those that want to legally participate in these types of events to go out there and have a good time. The problem that we are seeing is these trick drivers and these intersection takeovers are filled with people that do not want to be a part of those legal events. These are vehicles that have been modified. They're illegal for the roadway. They do not qualify for these events that are out there. And so they go, and part of the thrill of what they're involved in is taking over these intersections, creating dangerous situations, and they simply do not want to be a part of these. So the venues are out there and are open and available. They just don't take advantage of them. They still want to go out and be a part of this illegal activity and dangerous takeovers.
Okay, thank you. And then my question about the bill is in section 1 sub C, I understand that's, so that's the tow being allowed if the person driving is issued the citation for reckless driving. That's when a tow can occur. But in sub B, the existing language, if the person's driving and they're arrested, is there someone else? If there's someone else in the vehicle, are they allowed to take the vehicle? Like if you're arrested, you're driving. Is it an automatic tow, or can your friend take the car? If there's someone nearby, can they take the car for you?
Ashley Kennedy, Clark County. I will also pass that over down south as far as the process when that happens, when there's other passengers in the vehicle.
Officer Mike Teal, for the record. When a person is arrested or the vehicle is getting towed, in order for us to release the vehicle to a person, it has to be the registered owner. If the registered owner is the person that's either being arrested or cited, the vehicle is still towed at that point.
Thank you for that. Our next question is from Assemblywoman Considine.
Thank you, Madam Chair. My question is, I think, somewhat answered, but I think I just want some clarification on that point. I'm just trying to go through the NRS to connect the changes on page 8, section 3, subsection 3, as far as being able to get the vehicle back, as far as the owner. So if, and I know these are a lot of trick cars, so that the assumption is that the owner has tricked out the car and done all of this. But if the owner is not the person who was arrested or cited for driving the car, and the car is then towed, I think I'm a little bit confused about who can go back and get that car, or if that car is held for how long. Thank you.
Ashley Kennedy with Clark County. And sorry, Chair, through you to the Assemblywoman.
Please go direct.
Thank you. So as far as the timeline of if you get your car, if you are issued a citation and your car is towed, you can immediately get the car after it's been towed, as soon as the citation has been completed by the officers. I will turn it back over to the officers down south in regard to your other question, which was related to if the car is impounded but it wasn't the owner that was driving the vehicle.
Thank you. Our next question is from Assemblyman Gray.
Thank you, Madam Chair. First question, so when you said it had to be released back to the registered owner, is that specific to this case? Because I mean, I know, like, you know, if somebody's arrested for a DUI or driving without a license, a lot of times the officer's discretion allows them to release the vehicle to somebody that the driver is called or the registered owner is called, or a family member. So I'm just wondering if that's specific to this legislation. I don't recall seeing that in here.
Ashley Kennedy, Clark County, and I will pass this over to the officers down south.
Officer Mike Teal, for the record. Per our policy, LVMPD's policy, we can only release the vehicle to a registered owner that is papered and shows that they own that vehicle.
Thank you. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair, and good morning. Thank you for being here. My question relates to Section 2, Sub D, as in dog. If I could just understand, or the premises to which the public has access. You're looking for some authorization maybe to go on some private property, but the public has access. So I think I know what it means, but could you paint a picture of what kind of circumstances you're seeing this happen in perhaps, or could happen in the future?
Yes, Ashley Kennedy, Clark County, and I will defer to the officers down south, but from my understanding, one of the issues that has happened is driving displays happening in a warehouse area where it's private property and law enforcement can't actually go there to issue any type of citation or arrest. However, getting to that warehouse is a public road. And I will defer back to the officers to correct me if I'm incorrect or to clarify that a little bit.
Officer Mike Teal for the record. That is correct. In January of 2022, we had a very large truck driving event that took place in a warehouse that was currently under construction. During that time, we had several vehicles inside this warehouse that were performing their tricks, and one of the vehicles actually hit a structural pole that would have been, if it had been knocked 3 more inches to the left, is what we were told, is the entire roof would have collapsed on the racers that were inside there performing their tricks. Due to it being on private property, it's very hard for us to enforce this type of event because of being on that private property, and it did have access to the public.
Chair, just a follow-up to that.
Sure.
Thank you. So it was inside a warehouse. So how does it apply? For instance, if we have a business in what we call condo warehousing, and there's the parking lots, and some of these parking lots are really big. So we're not necessarily talking, do you already have the ability to go on parking lots for private businesses because the parking lots are for the public? So you're talking specifically inside a building, but you already have the access to parking lots if this is happening for private businesses that have public parking lots? Did that make sense?
Ashley Kennedy, Clark County. Go ahead, Officer Teal.
Officer Mike Teal for the record. It is both. We have it on both. They go to the larger warehouse areas for exactly what you just said. The parking lots are large, and they are able to go there and perform their tricks. We have warehouses that are over off of Valley View and Russell that are consistently calling us about the trick drivers that show up to take over the parking lots of their businesses as well.
All right,
And Officer Mike Teal for the record, sorry about that. And this change will help enforce both of those as well.
Thank you for that. Our next question is from Assemblywoman Mosca.
Thank you, Chair. Thank you for this. I know there's a lot of stereotypes when it comes to trick driving. Do we have demographics or who is arrested when it comes to trick driving?
Ashley Kennedy for Clark County. I don't have that information. I don't know if the officers down south have that on hand. If we don't, we are happy to report back.
Next question from Assemblywoman Hardy.
Thank you, Chair, and thank you for this presentation. So I just want to clarify that, does this bill, it applies to trick driving? Would it also apply, as you mentioned, to like instances of street racing? So that's the first question. Does it apply to anything in that realm?
Thank you.
Officer Mike Teal for the record. This would apply to reckless driving, trick driving, aggressive driving. It is all within the same law in this bill.
Please.
Thank you for that. And then as far as, so I'm just curious, so, you know, we've talked about the registered owner, the car gets towed, they can then go get the vehicle. And you mentioned that a lot of the vehicles, they're illegal to be on the roads in the first place. So then what happens, like they get their car back and then they could, you know, go do this again and get another citation. Is there anything done like to the vehicle itself since it's illegal to be driving in the first place?
Ashley Kennedy, Clark County. Go ahead, Lieutenant Rhodes.
Lieutenant Rhodes, for the record, currently when this vehicle gets towed to the tow companies, it's they're responsible to do the release of that vehicle as well. Also, one extra part of this is we have teamed up with the DMV. If a road is deemed to be unsafe, we can refer them to their investigators as well to take a look at that vehicle and make sure that any illegal modifications that are unsafe for the roadway are reversed on that vehicle.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for presenting this and answering our questions today. This is an issue in my neighborhood. There's a lot of racing and trick driving that happens in our neighborhood, and so I appreciate the attempt to address it. My question comes to, it really looks like the main change here is that now we can take the vehicle if they're doing this, right? And that should be a deterrent, hopefully, for people. In my neighborhood, sometimes police come and they'll watch for a little while. There's a main drag in my neighborhood where people go and they'll watch for a little while and they'll issue some citations and then it'll stop for like a week. And then they come right back and the police aren't there and it continues. And so I would just like to know, how does this new mechanism help discourage that? And also, do you have the manpower to effectively make a change in this space?
Ashley Kennedy, Clark County. Thank you for your question. And I will say, we find this as another solution or another step, right? Rather than arresting someone and towing a vehicle, we can issue someone a citation and tow the vehicle. It's just another option for us. And I will say, if you get issued a citation, your car is impounded, you can go pick up your car later that night after you have been issued your citation. And theoretically, yes, you could go and do trick driving again next week. I will say, as far as deterrence, just actually this week, Clark County, in collaboration with the Las Vegas Metro Police Department, installed these they're called safety transfer rubble strips on the intersection down south of US 93 and Grand Valley in Clark County. And when you're going through an intersection, as you should be, there's no damage to any cars with these rubble strips. However, if you are doing donuts in an intersection, they could damage your vehicle. So there was an incident in this particular intersection that was being taken over, and we had truck drivers who were having trouble getting fuel into Las Vegas. And so we just this week we're able to install those. And so I think we're trying to also come up with other ways to address this issue. As far as the manpower, I will defer back to the officers down south.
Daryl Rhodes, for the record. As far as manpower, it's about educating our own officers on the things that we can do in response to these takeovers. Obviously, we're in a city of over 2 million people, and these people, some of these trick drivers are committed to continuing this activity. And so what we want to do is continue to add tools that we can use to combat this illegal activity in our community to try to continue to make it safe. Being able to cite and tow is going to be a huge deterrent for some of these people because they realize that they could lose their vehicle temporarily, and I think it is another part that we can deter or make it so that they don't want to participate in this activity anymore. Another tool in the toolbox.
Thank you. We have a question from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you so much for the presentation. I'm a little stuck on the ability for you to access private property. And I'm stuck on that because I'm going to guess that a lot of this activity happens after hours. And I'm concerned about opening up a Pandora's box of allowing you to enter private property without permission from the property owner. And I understand this is a real issue, but I think that we have to be careful of what the existential result could be down the line. So today you're going after trick drivers. Next week, it could be something. Next year, it could be something else. And then all of a sudden, you are entering private property whenever you feel like it, warrantless. And so I'm concerned about that. Could you please speak to that?
Thank you, Ashley Kennedy, for the record, and thank you for your question, and I understand your concerns. I had a friend of mine pass me the NRS 484A.185, which defines premises to which the public has access to. And I will say, and you will hear later in testimony from our District Attorneys Association on why we needed this change to help us. But I'll just read the premises to which the public has access to, which is defined in 484A.185, means property in private or public ownership onto which members of the public regularly enter, are reasonably likely to enter, or invited, were permitted to enter as invitees or licensees, whether or not access to the property by some members of the public is restricted or controlled by a person or device. And I will say there are limitations. Does not include like a private way on a farm or a driveway of an individual dwelling.
Thank you. And if you're phoning a friend, maybe he can answer this part too. The officers gave the example of the trick driving happening inside of a building. Inside. So under your, under the amendment that you want, we're not talking the driveway. We're not talking the parking lot. We're talking inside a structure. So where does it end then? What's the cutoff here if now you want to make an amendment so that you can go inside private property?
Ashley Kennedy for the record, and I will defer to our officers down south, but in the section that we're referring to, so in section 2, where we're talking about the premises to which the public has access to, that is defined in this statute. So the term includes, but is not limited to, a parking deck, parking garage, or parking structure, a paved or unpaved parking lot, a way that provides access to a place of business, a government building, apartment building, mobile home, etc. So I would think the intent is not to go inside the building, but if they were in the parking lot, this would be covered. As far as if the warehouse is privately owned and we received a call, at that point, I think there is a course of action, and the officers down south can correct me.
We did, Officer Mike Teal for the record, we did receive a phone call from the warehouse owner. The owners of this warehouse had several warehouses where these trick driving events happened. And before any enforcement action was taken, we made sure that they did not have permission to be on there. And there was approximately $70,000 worth of damage done to a warehouse that they did not have permission to be at. But the provisions of this bill is for us to be able to go after for the access to the public. So that for the private property that has access to the public.
Okay, so first, just follow up on that. So you're saying on that specific instance, the owner of the property gave you permission to enter?
Officer Mike Teal, for the record, yes, that is correct. The owner of the property, when we knew that happened, we made contact with the owners, and they were the ones that wanted enforcement action taken.
Okay, thank you for that. And also, I would like to call up the DA's office, who is, I believe I'm clear on what you're trying to, on the difference between, so I just want to make sure, what I think is trying to be explained is that a private property with access to the public, I'm thinking like a Target's parking lot, right? That's private property, but the public has access to it, as opposed to our personal residential dwellings, which just wouldn't be defined by a driveway because not everyone has a driveway. It could be an apartment complex, a multi-dwelling home, my loft above a store, whatever, but my personal residence, Mr. Jones, can you define, because I think that's where we're getting caught up. So could you just define that for us?
Yeah, thank you, Chair Miller. John Jones on behalf of the Nevada District Attorneys Association. I think you said it rather well in your explanation there. So this is directed at parking lots and things of that nature. And I do want to note, when you read on page 4 of the bill, lines 1 through 11, this language is already in the reckless driving statute. So if you drive with willful or wanton disregard on a premises to which the public has access, that is already a violation of law. If you engage in an unauthorized speed contest and premises to which the public has access, that is currently a violation of state law. All this bill is seeking to do is to treat trick driving the same way that we treat unauthorized speed contests and driving with willful or wanton disregard. But in terms of the locations, Chair Miller, I think you did a great job of explaining. We're talking about parking lots and things of that nature.
Thank you. And could you give us an example? And maybe this would be, I may have to pull up our public defenders for this one too. Could you give us an example of when we know that a search warrant would be necessary? When would we be crossing into that where we would need a search warrant, that we would be restricted from entering the property, whether it's inside or outside?
John Jones on behalf of the Nevada District Attorneys Association, that's going to be very fact specific. Like, let's take the scenario given in the warehouse. And let's say the owner didn't call, but an officer drives by, the warehouse garage doors are all open, and the officer can plainly see that there's trick driving going on. If the officer can articulate that the people who are observing the trick driving display are in imminent danger of potential being hit by the cars or something like that, I think they could enter with a verified exigency. In other words, there's an emergency going on in there that the officer needs to control or somebody's going to get hurt. I'd also like to point out that if the owners or if the individuals inside are not the owners, in other words, they're not the owners, they're not the lessee, they don't have any legal right to be there, they would not have standing to assert the Fourth Amendment violation by the officers. Only the owner of the property could do that. So it's very complicated when you're talking about the Fourth Amendment with respect to these types of situations.
Would that be the only scenario? So let's take it outside of a warehouse and a structural building. What if it's just an open field that's, and again, I mean, technically, all land somewhere here, someone has a claim to. But, so let's talk about an open field where the owner is not obvious, and then compared to an open field, which actually may be owned by, it may be a family farm or a corporate farm or something like that.
John Jones on behalf of the Nevada District Attorneys Association. We do often see these cases in desert lots down in Las Vegas, and they're typically desert lots that are just completely open where people are entering regularly to cross. It may not be a situation where the owner wants them to cross, but it does happen. That's different than a family farm that may be fenced off, and you're talking about trespass law there as well. So it gets complicated. But if it's an open lot in Vegas, there's no barriers to entry, then I think that would be a premises to which the public has access.
Thank you. Mr. Pirro, would you come up and just wondering if, and I apologize for using the term farms, clearly that's where I grew up, but yes, here, mini desert. Mr. Pirro, do you have anything to add, or would you concur with the statements of Mr. Jones?
Thank you, Madam Chair. John Pirro for the record. I actually concur with Mr. Jones.
Excellent.
Hey, John Jones on behalf of the Nevada District Attorneys Association. Can I get a recording of that, please?
Ms. Thornton just literally said, so mark it, it is March 30th, 2023 at 8:34 a.m. So with that, just wondering if that, I think that's what we were getting to. Assemblywoman Summers Armstrong, does that clear up some of your questions, some of your concerns?
It does, Madam Chair, and I thank you for digging in. I think that was really important for me to understand. Thank you.
Thank you so much. Thank you, Mr. Jones. All right. I'm looking, it looks like someone's typing, but they're actually not typing, so. Oh, okay. All right, so with that, we don't see any additional questions. I will go ahead and open it up for testimony in support of Assembly Bill 408. So we'll start here first in Carson City.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. We are in support of AB 408. Thank you.
Good morning, Chair Miller. Good morning, members of the committee. Jason Walker, Washington County Sheriff's Office. This is a testifying in support. This is a major public safety issue, not only for the drivers that are performing the trick driving, whether it be 8th mile drag race or drifting along a intersection, but for the passengers also it's a safety issue and the onlookers. I agree with the Metro Lieutenant that to throw the illegal activity, the fact that if they could go to the drag setup there, they don't want to do that. It's the illegal activity of it that gives them the thrill. I also echo their comments. We do have this same problem in Washoe County as well, not to the magnitude of Metro. Luckily for us, we have snow a few months out of the year. The drifting contests aren't happening. We're doing it as a matter of driving down the roadway drifting. And I agree that the deterrent is the tow bills for this. So testifying in support.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. Just want to thank the Assemblywoman for bringing the bill. Want to thank Clark County and the Metropolitan Police Department for leading on this issue. We believe this is a good public safety policy and are in full support. Thank you.
Good morning, Madam Chair, committee. My name is Zach Bucher with the City of Las Vegas. We've seen a lot of these instances. We've seen an increase in these instances in our jurisdiction. We think this is a common sense tool that law enforcement can use to help address this issue. So we're here in support. Thank you.
Is there anyone else here in Carson City? Not seeing anyone? Is there anyone there in Las Vegas that would like to testify in support? Not seeing anyone. Broadcasting, will you open the lines, please?
To testify in support of Assembly Bill 408, please press *9 now to take your place in the queue.
Good morning, Chair, members of the committee, Nick Ciccone, City of Reno. For the record, I just wanted to say thank you to the bill sponsor. This has been a very large issue in Northern Nevada, and so I'm glad that our Southern Nevada friends have proposed this bill and will provide us these additional tools in our toolbox. Thank you very much.
Good morning, Chair Miller, members of the committee. My name is Greg Herrera, Herrera, representing the Nevada Sheriffs and Chiefs Association. Nevada Sheriffs and Chiefs Association are in support of AB 408, and we'd like to thank Assemblywoman Brown May in bringing this bill forward. Thank you.
There are no other callers to testify in support at this time.
Just one moment. Okay, with that, I will go ahead and open it up for testimony in opposition of Assembly Bill 408.
Good morning, Madam Chair and members of the committee. John Puro from the Clark County Public Defender's Office. We agree with this idea in concept, adding a consequence to the actions. One of the things that we're concerned about is the tow fees. It's about 200, and I ran these numbers with Ms. Kennedy. One of the things is it's about a $280 tow fee, and then the tow truck yard will charge you per day there. So We have a conceptual amendment, and that's why we're in opposition. Assemblyman Miller, we think, has a good measure in Assembly Bill AB 303. That kind of deals with tow fees and ability to pay. And so we'd like to propose that in this bill so that somebody, let's say a teenager, may be using the family car in an inappropriate way. You don't want the family to lose the car. You want the penalty, you want that to happen, but you don't want them to lose the car for good. Or you don't want somebody to lose the car that gets them to and from work so that they could pay these, because the reckless driving citation is also going to cost money. Insurance is going to cost money because of the points on the license. So we don't want to destroy somebody's life completely, but we do want to stop the bad behavior. So we're offering a conceptual amendment in this regard, and hopefully the bill could pass in that capacity. Thank you.
Good morning, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. I echo the sentiments of my colleague. I think that in the concept of the bill, it does make sense. The behavior is disruptive to the public. It can be dangerous, right? And so, but we don't want these collateral consequences to ultimately ruin someone's life. So if the family car is relied upon for a parent to get to work, we're hoping to take that into account when we're thinking about it. And then lastly, I would be remiss to not mention, being from the Bay Area, that the correct term is a sideshow and not trick driving.
Is there anyone else here in opposition in Carson City for Assembly Bill 408? All right, is there anyone in Las Vegas in opposition? Broadcasting, will you open the lines, please?
There are no callers at this time.
Thank you. Then I will go ahead and open it up for testimony in neutral. If there's anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Is there anyone in Las Vegas? Also not seeing anyone. Broadcasting, is there anyone on the lines?
To testify in neutral to Assembly Bill 408, please press *9 now.
Good morning. Before I start, I'm actually testifying in support, but I got bumped off the line before, so I'm not sure if you can still take that testimony.
I will allow it. Please proceed.
All right. Thank you. Good morning, Chair, members of the committee. My name's Jody Hocking. Well, I'm usually here. Oh, hold on one second. Oh, never mind. I got bumped off on the wrong bill. I apologize. I'll wait.
Yes, we're expecting you on the next bill, but thank you for that. And are you co-presenting on the next bill, I believe? No. Okay. All right. So call in and support the next bill. Okay. So with that, I will, broadcasting, is there anyone else on the line?
There are no other callers at this time.
Okay. Thank you so much for that. With that, then I will welcome Ms. Kennedy. Do you have any closing remarks?
Thank you, Chair Ashley Kennedy with Clark County. I just wanted to say thank you for allowing us to present this bill today. And I know that the Assemblywoman Brown May has been in discussions with the Public Defender's Office, and we will continue to work through some of their concerns and hopefully present you something that we agree to. Thank you.
Okay, thank you. With that, I will go ahead and close the hearing to Assembly Bill 408. Okay, with that, we will move on to our next bill, which is Assembly Bill 369. Assembly Bill 369 revises provisions governing the administration of justice. There are a number of people listed as presenters, so I'm just going to hand it over to our sponsor, Assemblyman Ornlicker, and let him introduce and exchange and rotate out the multiple speakers as he sees fit. With that, Assemblyman, your bill hearing is open. Please proceed.
Thank you, Chair. David Ornlicker, for the record, Assembly District 20 in the southeast side of Las Vegas. And thank you for the opportunity to present Assembly Bill 369, a bill that Assemblywoman Cecilia Gonzalez and I are co-sponsoring together. And we're grateful for our partners in this effort, Lisa Mosley and Nick Shepak at the Fines and Fees Justice Center. They do great work to achieve a fairer system of fines and fees, and they translated the concepts we will be discussing into the bill you have before you. And please note that we will be discussing the conceptual amendment of the bill. It's the entire current version of the bill. We're also joined on Zoom by Professor Eve Hanan from the UNLV Boyd School of Law and two of her students, Shaylin Dieter and Ryan Edwards. Ms. Dieter and Mr. Edwards have studied fines and fees in their misdemeanor policy course with Professor Hanan at Boyd Law, and their terrific analysis is one of the exhibits posted on Nellis. In addition to the fines and fees part of the bill, Section 11 addresses a gap in our law that we have for protecting public officials from threats or intimidation. Tribal Judge Patricia Lenzi, next to me, alerted me to the problem and is here to discuss it this morning. So two parts to the bill: the making fines and fees fair for offenders and protecting tribal judges. So I'm just going to do a brief overview, and then we'll turn it to the students in Las Vegas to talk more about the fines and fees, and then Judge Lenzi will wrap up with Section 11. So why are we doing this? Well, it's a very familiar adage: the punishment should fit the crime. Somebody who, taking the speeding that example, if you're driving 10 miles over the speed limit, you might have a lower fine than somebody who drives 50 miles over the speed limit. So it's very important that punishments be proportionate. But if you fine everyone the same amount, that means we punish lower income offenders more severely, because the amount of the fine, how it impacts you, depends on how much you earn. So here's some examples. If you had a $200 fine and you're earning $20,000 a year, that $200 fine is 2.5 days of your income, assuming you earn 5 days a week. That's a stiff fine for you. Somebody who's earning $80,000, it's less. It's now or less than a day. Still more than half of a day, but compared to 2.5 days. And then if we get up to somebody who earns $800,000 a year, it's less than 10% of their day's income. So if we're concerned about deterring people, and one person, it's only less than 10% of their income as opposed to 2.5%, we're just not going to have the same impact on the offender, and that's not right. And for low-income offenders, when we get to the very low end, fines and fees for minor violations may be unaffordable. We just had the example from the public defenders about what happens if you tow the family car, and that may make it impossible for them to get to work. So these kinds of fines and fees, the offenders may not be able to pay if they're really low income, and now you've imposed $200 or more. It can mount up quickly. Now, what about their housing, their food, their child care, their transportation? How are they going to get to their job? The offender for some of these offenses, they may go to jail for failure to pay, and then they can lose their job, their housing, etc. Okay, so that's the fines and fees overview. And then the other part, Section 11, as I said, we protect public officials in our state from threats or intimidation. There's a statute for that. But our statutory protections don't apply to tribal judges who live in our community. They're not living on tribal land. They may be our neighbors, and they're serving as tribal judges. And as you'll hear from Judge Lindsay, they can be subject to very unfortunate and severe threats and intimidation. Okay, so let me now turn to, good, I see them on the screen, Professor Hanan, Shaylin Dieter, and Ryan Edwards, who'll talk more about why it's so important that we adjust fines and fees based on the income of the offender.
Thank you, Dr.
Oh,
Orlicker.
I'm sorry, I forgot one more thing. Sorry to interrupt. Let me just, basic provisions. So the fines and fees provisions that adjust based on income for minor so the fines and fees provisions that we're applying, this is not for all offenses. This is for minor traffic violations and misdemeanors. That's in section 4 of the bill. And we're proposing a waiver of fees for people below 200% of what's called the very low income level. This comes from a federal Affordable Housing Act, which defines what it means to be low income for purposes of housing affordability. And so in Nevada, the very low income level is for a family of 4 around $40,000. It varies by city, but it comes out around $40,000. So waive fees on the lower income side, and then reduce the fines by a particular amount depending on their income. So at the higher level of low income, they may get a 25% reduction, then a 50% reduction, 75% reduction, and ultimately at the very low income level, a full waiver of fines subject to a minimum of at least $10. And some offenses have a minimum fine that would be preserved too. So the lower the income, the less you pay. But you'll always have to pay something. And then finally, add tribal judges to the list of public offenders protected from threats or intimidation. That's section 11. So those sections 4, 5.2, 5.3, and 11 are the major substantive part. There are definitional sections and so on, but those are the kind of core parts of the bill. And now, thank you, let's turn to Ryan and Shaylin and Professor Hanan.
Thank you, Assemblyman Ortlicker. And my name is Ryan Edwards, and my partner Shaylin Dieter and I are both students at UNLV's Boyd School of Law. And last semester we were in Professor Hanan's misdemeanor policy practicum course. The project we did in that course was researching how similar reductions of fines and fees by ability to pay regimes have worked. And as part of that, we did legal research, of course, it being law school. We also did some fact-based research, academic research, and we participated in quite a few court observations at both the justice and municipal courts located here around Las Vegas. And one of the first things that we always heard, especially at the courts, when they found out about our project, was some form of saying, well, we already do that. Now, of course, there are currently alternatives to simply paying in full any fine and fee that is assessed to you, and we talk about those on page 2 of our report. But right now, the 4 options that someone has instead of just paying in full are first to set up a payment plan where they pay some predetermined amount per month or week until they've paid off everything. The second one is to participate in a work program or community service program, which works off the fines and fees at a rate equal to the state minimum wage, which right now sits at $10.50 per hour. A third option, though not very popular, is to work off the fines and fees by serving in jail, and that eliminates fines and fees right now at the rate of $150 per day. And of course, the fourth option that does exist is that a judge has discretion under Nevada statutes to reduce a fee and fine. However, in all of our court observations, we never really saw that option taken. The most common thing is to simply tell people to set up a payment plan or enroll in the community service. Now, we use sort of as an example a baseline fine and fee assessment of $300, which seems like a reasonable amount to assume for a lot of these traffic violations that somebody might incur, and explain how some of these alternatives are merely conversions of one unit of punishment into another. And so a $300 fine and fee total would take 28 and a half hours of community service to absolve. Or if you were unfortunate enough to resort to the jail option, that's 2 days in jail. And one of the things we try to highlight is that we choose a fine or monetary amount as our default unit of punishment, but it could just as easily be one of these others, and you might similarly see some inequities. So for example, if all violators of this hypothetical traffic violation were assigned 28 and a half hours of community service, it might seem unseemly to then let anyone of means simply pay $300 to get out of that punishment. Of course, there's a reason that we use the standard unit of punishment of money. Part of it is that it's simple to administer and simple to understand, but also it's a substantial source of court funding in Nevada, but also in other states. And so another big question we often get is, how will Nevada afford this? Now, as we talk about on page 12 of our report, Nevada does not cumulatively track outstanding fines and fees. It also doesn't track as a separate expenditure the amount that's collected or anything that is, as an asset due. We also don't know anything about the overall collection rates. Somewhat of as a proxy, you can see in the court's annual reports the amount of administrative assessments that are recovered. And those do show a substantial portion of money coming in, several $1 million, and those are specifically used to fund specialty courts. In lieu of specific data from Nevada, though, we can turn to other jurisdictions that have implemented a similar fee scaling provision. And we discuss some of those on page 14 of our report. In each of those, collections and revenues have modestly increased or stayed the same. And you see this in, excuse me, in California, which recently implemented a system just a few years ago. And so they've had a few years of data to assess. And some of the reasons for this is simply that you have increased collection rates and less oversight. People don't need to come to the court as frequently to get checked up on. And then there's also the additional fines that accrue in choosing one of these alternatives. For example, the payment plan and community service also have an additional fine attached to them in addition to the fee that you're working off or paying off via the plan. Other states that have implemented this, we also saw the number of outstanding debts and administrative costs and burdens going down, as well as collateral consequences such as outstanding warrants being issued for failing to pay and driver's license suspensions. And I'm going to turn it over to my partner, Shaylin Dieter, who's going to talk about a couple of our other issues that we identified. Thank you.
Thank you, Ryan, and thank you, members of the Assembly Judiciary, for having us here today, and to Assemblyperson Orton-Licker. This has been a wonderful opportunity, and we're looking forward to answering some of your questions as well. To follow Ryan's point about some of the common questions that we would get and we anticipate you might have about this bill, one thing that we get, because we all have an internal pessimist inside of us, is what about people who might lie about their ability to pay? We have a two-part answer to that question, which we think might cure any concern. So first, Nevada already implements two ways in which individuals who are coming from a lower income standpoint can receive waivers of filing fees in civil settings. And as many of you know, public defenders when they are accused of criminal offenses. So we touch on both the IFP, the Informa Pauperis form, as well as the PD forms to reflect on the questions that are asked and to draw comparisons between how a form that is proposed in AB 369 might play out in reality. In addition to that, both the IFP form and the PD form contain, as you can see on pages 9 and 10 of the report that we submitted, anecdotes which require individuals to claim the information that they are stating under the penalty of perjury, which gives folks a bit of an incentive not to lie. And additionally, we did substantial research on the implementation of such standards on other court systems. And much of this gets to the point that individuals often underestimate the income that they make and rarely lie on forms such as these. moving forward to a further question which stems directly to this, how will our courts, particularly our justice and municipal courts, which are moving at a fast pace with a high saturation of cases, implement these types of forms during a very quick proceeding? If any of you have observed a justice or municipal court setting, an individual might take no more than 30 seconds to submit a guilty plea to a traffic ticket or to a low-level misdemeanor offense. So similarly, we point back to the IFP or the PD form. The IFP form is a form individuals file prior to a civil action or alongside the filing of a civil action, in which the court then reviews it, waives the filing fee, and notifies the individual after the action has been filed. This is dissimilar to what our understanding of AB 369 would implement for the filing form, which would be more similar to the PD form, in which individuals quickly fill out information pertaining to their household income, monthly income, Social Security benefits, and so forth, and briefly submit that to the clerk of the court, who hands it to the judge, who reviews that for accuracy. That takes a quick process. I'm sure if many of you have observed the initial appearance process, it's an incredibly fast paced as well, and takes essentially no time. So implementation would hopefully not be an intense burden on the courts. In addition to that, we just wanted to stress that, and I'm sure Lisa and Nick will talk about this from Fines and Fees Justice Center, that this is a compliance bill. We want to ensure that individuals are taking responsibility for the traffic offenses that they commit and for the low-level misdemeanors that they might commit. However, imposing a heightened fine or fee on individuals of low income status creates an unreasonable and frankly unfair implementation of justice. Individuals should not have to choose whether they want to put food on the table for their families or pay their $100 monthly payment plan towards a traffic ticket that they received 6 to 12 months prior. So I wanted to thank each of you once again, and I'll turn it to Professor Hanan to talk a little bit about our experiences outside of Ryan and I's coursework, but when Professor Hanan got to work with individuals who were facing fines and fees in the misdemeanor clinic.
Thank you. I'd like to say good morning to the committee and thank my students as well for their wonderful work on this report. I am Eve Hanan. I'm an Associate Dean and Professor of Law at UNLV. I also practice law in the Thomas and Mack Legal Clinic, where I supervise students who represent people charged with misdemeanors. These are folks who don't get a public defender because they're not facing jail time, they're facing fines and fees. So our practice in the clinic is essentially a fines and fees defense clinic in the justice and municipal courts. So in that capacity as an attorney, I'd like to just share a vignette of a client who I will call Darlene, who the clinic students represented. She lives in rural Clark County. She lives in a trailer and she has no access to public transportation nearby. Around 60 years old, she is trained as a hairdresser, and before the pandemic, she rented a booth in Boulder City in a salon. Of course, when the pandemic hit, the salon closed and she lost her source of income. And what quickly followed after that is that she couldn't make her car insurance payments and they lapsed, her insurance lapsed. So her registration was suspended and she was pulled over for driving without insurance and without a registration, a ticket to go into Henderson Municipal Court. She went to the court and she told the judge that she was unemployed and didn't have money to pay the ticket. And the judge said, your option is community service or paying on a payment plan, which also costs another fee. Because she lived so remotely and didn't then have a way to drive to get to the sites of the work program for Henderson, she agreed to the installment or the payment plan. However, even that amount was too much for her to make and a warrant issued for her arrest. She called us. It was the first case in her life, the first warrant certainly in her life. She was weeping, she was terrified, and she felt trapped in debt. She couldn't pay the DMV fees to reinstate her registration and license. She couldn't get her insurance reinstated, and now she had a warrant out for her arrest. She was in a vicious downward spiral with increasing debt and hopelessness. And what we have found is that she's very representative of our clients. She's one of many. She wants to comply with the law. She wants to follow the rules, but it's basically been made impossible for her. What we have found in the clinic is that when we ask judges to waive or reduce fines and fees for clients such as Darlene, we're told that the options are community service, often many hours, close to 100, sometimes more, or a payment plan that will go on, almost indefinitely for some of these clients. And our opinion is that that's just simply not fair for someone like Darlene. What would be fair is if at the first appearance, a judge would assess her ability to pay and scale the fines and fees according to her circumstances. As you've heard from my students, the statutory scheme permits these reductions and waivers, but there's really no procedure in the statute that ensures implementation of this fairly and consistently. And so it's our position that these years of impossible installment payments or hours of community service is just simply not equal justice for someone like Darlene, because it's a ticket that you or I could pay with a few clicks on our laptop. So thank you again to the members of the committee and to Assemblyperson Orntlicher for bringing this bill, and I'll turn it over now to the next speaker.
Thank you, all of you, for presenting today. And now, Judge Lindsay, as I say, this is Section 11 of the bill.
Thank you. My name is Patricia Lindsay, for the record, and I want to thank the committee for allowing me to speak to you all today, and especially to Assemblyman Orntlicher for sponsoring this bill or authoring this. My name's Patricia Lindsay. I'm a member of the St. Regis Mohawk Tribe, and I serve as Chief Judge for the Winnemucca Indian Colony Tribal Court. I'm a conflicts judge for the Urington Paiute Tribe and the Duckwater Shoshone Tribe here in Nevada. Among other tribes, I serve in other states, including as Chief Judge for the Cedarville Rancheria of Northern Paiute Indians. My work takes me across jurisdictional boundaries of many tribes throughout Nevada and California. I am a citizen of the state of Nevada and the United States. I reside in the jurisdiction of Douglas County, not on the lands of any specific tribe. Tribal court cases are all civil and criminal cases, just like state courts here, everything from probate to homicide. I want to share with you two specific situations I have personally experienced to explain why I'm here to support the amendment to NRS 199.300 and contained in AB 369, Section 11. On February 20th, 2014, I was serving as a conflicts judge at the Colorado River Indian Tribes in Parker, Arizona. That day, I was also appointed as chief judge at the Cedarville Rancheria in El Torres, California. I was sworn in telephonically because I was in Arizona. The very first hearing was also held telephonically for that reason. The only reason I am alive and here to tell you about this today is because it was a telephonic hearing from my part. It was a housing eviction case, and the person being evicted brought in 2 9mm handguns, took them out of her backpack, killed 4 people in the room, and wounded 2 others. When her guns jammed, she got a butcher knife and cut the throat of one of the people in the room to make sure he died. I found out that some of the people that were potentially involved and supportive of the shooter lived in Reno. I live in Douglas. I went to DMV to have a confidential license plate put on my car. It turned out unless I was a domestic violence victim, I could not have that done. I had to find a court case to take into Nevada court. Well, there was no category that fit me, so I could not have that done. Then I was later appointed as chief judge for the Winnemucca Indian Colony. I have since been appointed, I was a conflict judge there, and now I am chief judge. I presided over a very contentious housing eviction case. The former chief judge had recused himself, and I know Assemblyman Orntlicher has a copy of the order where he recuses himself. I urge you all to read it. There is also a letter of support from that particular tribe regarding it, and I ask you to read that too. While that case moved through tribal court, I became the object of a campaign to attempt to convince me to stop serving as judge for that tribe, to disqualify myself. There were Twitter and Facebook posts about me, images about me, information about my family and my personal life. There was a letter writing campaign to my tribe and every single tribe where I serve as a judge. It actually was cited as one of the reasons that the Washoe tribe told me they felt it was unsafe for them to continue having me as their judge. Meantime, several incidents occurred on the colony lands involving charges of assault on federal officers, among other charges. Anonymous letters were mailed from Reno and Vermont. They were sent not only to me at my home and to every tribe I work for and my own tribe, but to every one of my neighbors by name, naming every adult member of their household, including their adult children. And the letters were sent from anonymous people claiming to be concerned citizens. The return addresses showed the Winnemucca Indian Colony or my husband's name and our home address. Needless to say, my neighbors were quite disturbed. The letters urged people to hunt me down at the grocery store, stop me, do whatever they can to prevent me from presiding over these cases. Go to my house, knock on my door, find my family. I decided I should make a police report. I called Douglas County Police. They said it's a tribal matter because they don't understand jurisdiction. And even though I live in the county and these came to my house and my neighbors, and it is stalking under Nevada law, I could not get a follow-up investigation from a detective. Under federal law, I made a report to the BIA, the FBI Major Crimes Task Force. It turns out it falls in a loophole of federal law. Under Nevada law, tribal judges are treated like any private citizen. Under California law, where I preside at Cedarville, private citizen, but for the fact that it was a quadruple homicide that went through their state courts because of jurisdiction in their state, that case, nothing specific was done for me because I live over state lines. So I'm asking you to consider that every single one of the 27 tribes here in Nevada has a judge that doesn't live on tribal lands, that all live either out of state or somewhere in Nevada, but not on a reservation. Some are tribal members, as I am, but not of the tribe we serve. Some do serve their own tribes, but they live off tribal lands. We all drive across jurisdictional lines to get to and from our courts and to perform our services. So I want to ask you to amend 199.300 of the NRS to add tribal court judges. And I thank you for your time, and I thank you, Assemblyman Orntlicker.
David Orntlicker, for the record, thank you, Judge Lindsay, for sharing your experience. That concludes our presentation. I will say we have heard some concerns that we haven't had time to work out a conceptual amendment, but we are eager to sit down with the people who have concerns to work out revisions, and we will do that as soon as we have time.
Okay, thank you for that, and thank you for the presentation. So before we begin questioning, Assemblyman, there was an amendment proposed by Fines and Fees Justice Center. Is that a friendly amendment?
David Orntlicker, for the record, yes.
Okay.
That is designed to replace what you saw as the official version of the bill and to do some tweaking and make sure we get things in better form. Thank you for asking.
Okay, thank you for that. With that, we will go ahead and open it up for questions. The first question is from Assemblyman Gray.
Thank you, Madam Chair. So with regards to the fines and fees and the person being able to, have their fee on a sliding scale based on their income, all they have to do is sign an affidavit declaring under penalty of perjury that they're telling the truth. Is there going to be any requirement to verify that? I mean, it seems like the payoff is almost bigger for them to lie than it would be to, tell the truth.
Nick Sheepak for the record, Deputy Director of Fines and Fees Justice Center. May I go direct, Chair?
Yes, please.
Thank you for the question, Assemblyman. Evidence shows that people do not lie on this. Well, under penalty of perjury, it's the same thing with a public defender. In California, where they did a comprehensive study of their program, they found that 88% of people who sought these waivers lived under the poverty line, and 46% of those individuals received at least one, if not multiple, benefits. States that have implemented this with simply the penalty of perjury in the waiver have found that the vast majority, if not all, individuals are truthful in their income. In fact, what studies show is that people often overestimate the amount of money that they make, not underestimate.
Thank you for that. Our next question is from Assemblywoman Hardy.
Thank you, Chair. And thank you for this bill presentation, and also to the students for their work on this. So I just had a couple of things, and so I think you mentioned this bill talks about a form that the court would have, and this is different than the form that currently exists for civil action in the public defender form. And I think it's mentioned in the first section there about just how the court would go about calculating the monthly income, and then it references the Home Investment Partnership Act. So is that a form that currently exists, or that would have to be developed?
Nick Sheepak for the record.
I'm sorry.
There's guidance for a form, but seeing as Nevada does not have a unified court system, courts could modify the form that would best fit their court system. There's guidance for what would be on that form. However, we have not included in the legislation at this point a mandate that each form looks identical, as courts don't always operate the same throughout the state.
If I could jump in as well, Shaylin Dieter for the record, to add some additional insight on that. Assemblywoman, if you look at page 7 of our report, we include a Fines and Fees Justice Center ability to pay application sample. We got to talk with Ideas 42, who discussed some of the behavioral elements of that with us. We think that's a really insightful way to look at it and discuss kind of the simple implementation and how it could very easily allow courts to assess an individual's ability to pay.
Okay, thank you. Our next question is from Assemblywoman Gallant.
Thank you, Chair. I would be interested in seeing that study, just because on a personal level and like what I've gone through in the last 2 years in terms of the rental assistance and the income verification was based on, like, there was no verification. It was just based on report. And I can say I put more rental assistance applications in for my Section 8 tenants than any of my other tenants. And if their income hadn't changed, Section 8 would have picked up the full, right? So I know, like, all of those applications were probably done under fraud. And that is also under penalty of perjury when you're filling out those applications. So I just want to make sure that the right people get assistance and that those other people are not going to exploit this this system and this process.
Hanan, for the record. Oh, sorry. I just wanted to speak anecdotally, but from the misdemeanor clinic experience over the past, I guess when we started in 2018 with it, just the transaction costs of going to a municipal or justice court and waiting sometimes for half the morning or half the day for a case to get called is such that perhaps in this context, when you're looking at a ticket that's probably between $200 and $800 to start out with, it's less likely that somebody with means would spend a day of their time going to court to fill out the form to state to the judge that they made less than they do unless they really needed it. Most people who have the money to pay the ticket can do it, certainly in traffic cases, in some other cases as well, with low transaction costs, from the comfort of their home on online platforms. So I think that does reduce the chances of fraud for this particular type of income assertion.
And Nick Shepak, for the record, to add to that, the study that we referenced from California, which just came out, it's very recent, published in 2023, studied for the last, I believe, 4 years, is in the exhibits in NALIS. No, you're totally fine. You will find it in there. And if we have other information of a similar value, we will make sure to get that to the committee.
Thank you. And with that, we have a question from Assemblywoman Cohen.
Thank you, Chair, and thank you especially to the students and to Judge Lindsay. So I just have some technical questions. In Section 7 with the presumptions, are those, so the word there is presumption, it doesn't say rebuttable, and I know that's existing, that language is existing, but then you've got the list like has experienced homelessness, has received treatment in a psychiatric facility at any time in the preceding 6 months, and that presumes that people who have had treatment in a psychiatric facility aren't on their feet, aren't capable of caring for themselves, paying fines, that type of thing. So I want to, I guess, ask about, again, if those are rebuttable and why those were put on the list.
Lisa Mosley from Fines and Fees Justice Center. So much of this came from our guidance at the Fines and Fees Justice Center, and the provision for anyone experiencing being in an institution or anything was part of that guidance. And yeah, the assumption was that if someone has experienced that and has been in an institution, then could be a presumption that they don't have the ability at this point financially to pay that. We are okay with amending that out if we need to. But that's where that came from. And also with the presumption is initially what we were thinking is that anyone who meets any of these presumptions just doesn't have the ability to pay based on our guidance and what we've seen. But also anyone who does not meet any of those criteria, we wanted to be able to capture those folks also, which is why we included the actual ability to pay assessment. And so does that answer your question?
Yes, I mean, I'm not necessarily saying that I want those out, but maybe just putting in rebuttable. And then, Chair, if I could just have another related question.
Sure.
Okay, thanks. And then the home program, I can't remember the name, the program where you're basing the poverty level on, why was that chosen instead of the federal poverty line?
Nick Shepak, Fines and Fees Justice Center, for the record. This metric was chosen because we believe strongly that the federal poverty line is too low, and that this more accurately represents what low-income is in Nevada. If you look at a single individual at the very low income standard in Reno, Nevada, they do not make enough money at 200% to afford an apartment, according to all recent studies in Reno for what it would cost to afford an apartment. And the federal poverty line is slightly lower than that. We believed that it was important to capture people who struggled with housing into the very top level of these deductions.
Okay, thank you.
Thank you for that. With that, I would actually like to call the judge back up because we do have a question for the judge. Our question is from Assemblywoman Hanson.
Patricia Lindsay, for the record.
Thank you, Madam Chair, and thank you, Judge, for being here. I'm so sorry to hear what you've been through, but appreciate the work you do. So I looking at Section 11 and adding in this language, including without limitation a tribal judge, I was surprised that I was thinking judges do have protections. And when I read this existing language of NRS 199.300, it says a person shall not directly or indirectly address any threat or intimidation to a public officer, a public employee, a juror, a referee, an arbitrator, appraiser, assessor, or any person authorized by law to hear or determine any controversy or matter. In existing language, I didn't even see judge in there, so I'm assuming there's a different statute that does it explicitly say judges? And a follow-up would be to that. Well, if we could, let's just deal with that. I'm trying to find out where is there protection for judges, trying to understand why tribal judges don't fall into that category.
Thank you for the question, Assemblywoman. I would say that I am not a Nevada licensed attorney, so I would bet that the Nevada District Attorneys Association would know which section mentions judges, if not Assemblyman Orntlicker. But most often the state definition, when I read it for any type of judicial officer, referred to officers that preside over Nevada state type of cases. So it really tied it to the state.
And we can have legal respond to that as well.
Thank you, Chair. Judges would actually be covered under two provisions. They're public officers, the very first term in the statute, and they're also persons authorized by law to hear or determine any controversy or matter.
Thank you.
Okay.
Thank you for that. So a judge falls under public officer. So I've been educated. I appreciate that. And then.
So have I.
Are you asking for a follow-up?
Yes, I am. I'm sorry. Thank you. So because you're over multiple jurisdictions then, oh, I know what it was. I'm sorry. You mentioned that you don't live on tribal land. You live, so is the law for those that, if there's a tribal judge that lives on tribal land, they are protected?
Thank you for the question, Assemblywoman Hanson. Patricia Lindsay for the record. And under the tribe's law, the judge would be protected if the tribe has a provision, and every tribe has different laws. Under federal law, most tribes are limited to a maximum of 1 year punishment for even the most heinous crimes. Homicide, we have misdemeanor murder, misdemeanor child molest, misdemeanor rape, and robbery on every reservation across the country, except for the few that have elected to amend their codes under certain new changes to the federal law in the last few years. So most tribes, that is the limitation. I know under Washoe's law, I believe it was 6 months to a year that if I were physically assaulted, 6 months. And that's their law. But under federal law, it has to be an explicit threat. So even crossing the jurisdictional boundaries, there are so many nuances to federal law that we're not protected, especially there. And we judges across the country at tribes have sought to make this change. So Nevada would be a leader if you do. Thank you.
Thank you.
May I add one thing?
Yes, please.
The problem with Douglas County was that they misunderstood their jurisdictional boundaries by naming tribal judges specifically under Nevada law. It would help be a tool to law enforcement to understand that, yes, they actually can do something. Thank you.
Thank you. We have a question from Assemblyman Urick.
Thank you, Chair. I was curious curious, with the addition, it looked like for the assignment of community service, requires supervision, obviously. And it looks like we're adding some language here that allows supervision to be accepted or supervised remotely. Can you help us understand what that might look like for a remote supervision?
Nick Shepak, for the record. So the expansion of community service, first of all, is based off of the Texas statute. Texas has the most expansive community service statute in the country. Remote supervision could be in a situation in which somebody is completing a task. It is clear that that task has been completed once it is done, right? But that you don't need an on-site supervisor for that entire time, right? So you have somebody who is participating in some sort of program. They're able to show that they have completed the program, whether that is through a certificate online, whether that is through, say in this situation, we've opened it up so that somebody could go and get some sort of education, right? You have somebody who is getting misdemeanors because they are unemployed. So they get a certificate that shows that they have participated in a work first program that is going to educate them. The supervisor could be off-site. That it signs off to the court. Yes, Nick Shepak brought me the papers that documented that he had completed this thing. I am approved by the court to supervise this type of service. Maybe it's even somebody like Hope for Prisoners, right? So the supervision doesn't need to be an on-site person necessarily. We are talking with some of the courts and they want clarity on some of the language around different aspects of the community service provisions. And so we're going to work with the courts to figure out the best way to clarify so they know, judges know exactly what supervision looks like and what the types of community service are.
Continue with your follow-up.
Thank you, Chair. So I just want to clarify, by that example, an individual could come in with the addition of misdemeanor crimes. A defendant could come in and say that they're having trouble meeting their financial obligations, and so perhaps say the crime was misdemeanor theft, something like that. And the defense is that it's because they don't have a job, and then the community service could be giving them some sort of education to help them get a job. And that could be done remotely or online and could be validated through a certificate. Is that, as I understood your example, would that be accurate?
Nick Shepak, for the record, that is correct. The idea is that we want community service to benefit the individual and the community, and we believe that those types of paths will benefit. If somebody's stealing because they don't have money and they spend hours working towards obtaining a job, we all benefit as society.
Thank you. And with that, not seeing any additional questions, I will go ahead and open it up for testimony. So first we'll start here in Carson City with anyone that would like to testify in support of Assembly Bill 369.
Good morning, Chair, members of the committee. Erica Roth, E-R-I-C-A-R-O-T-H, on behalf of the Washoe County Public Defender's Office, testifying in support this morning. I'll keep my comments brief, but this bill simply makes sense. And I think that what I do want to add, however, is that when we're talking about fees and what happens if they're not paid, right? That money's being spent otherwise. So when I first started as a public defender, I was doing misdemeanor bail hearings. And when you show up to the jail in the morning, you talk to all the clients in the jail, and there's a certain number of them who were on their way to work, were pulled over, and didn't know they had a warrant out for their arrest for some traffic violation or a fee that wasn't paid. They have to be then processed, booked, their car is towed. And then sometimes they elect to just spend time in jail to satisfy that fee. There's a certain amount, a dollar amount per day that they would get as credit towards that. But that costs the county money. That costs money to do all of these things. And so it makes more sense to expand that to make sure that maybe they are able to do community service and give back to the community. But that there is a cost that is borne that needs to be considered as well. Thank you.
Wiz Razar, Deputy State Director with Americans for Prosperity, and that's spelled W-I-Z, last name R-O-U-Z-A-R-D. We thank the bill sponsor and the chairperson for bringing this bill forward. We support this bill. We've worked very diligently in ensuring that our correction system works properly. And this is just reinforcing the Eighth Amendment when we talk about excessive fines. The Founding Fathers understood that there is a due process that should also be applied when it comes to monetary means for things like what we're talking about here today. And we believe when we talk about our society, we want to make sure we're putting people in a position to actually correct their action, not put them in the position to be more so harmed by the actions of government. And so we believe that AB 369 does create a beautiful framework where we can achieve that goal in making sure that those who are least fortunate have the ability to actually correct their actions, but also still be able to contribute in society. So we greatly support this bill, and we urge you to vote yes on this bill, AB 369. Thank you.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office. We think this is a great common sense solution to some of the problems we're seeing in court, and will provide a good pathway for people to get on their feet during this time without taking them out of the game for too long. We urge your support.
Good morning, Chair and members of the committee. My name is Lilith Barron, Lilithbaran, with the ACLU of Nevada. We strongly support this measure. I will echo the sentiments of my colleagues. Excessive fines and fees oftentimes prevent folks from getting to work efficiently, paying other bills, and they're having to choose between life-sustaining measures and paying a court fee for simply being late on registration or insurance or something like this. So please take that into consideration. Thank you.
Good morning, Chair and members of the committee. My name is Maria Teresa Lieberman Barraga, MARIA-TERESA. LIEBERMANN-PARRAGA, and I'm the Deputy Director of Battleborn Progress, and we're in strong support of this bill. One, to keep our tribal judges safe, and then the other part to make sure we're giving Nevadans some relief. Connecting this to sort of the economic landscape that we're living in, I'm sure both legislators and people just monitoring this legislative session have heard in various, whether it's housing or other economic issues, Nevadans are struggling, and this would be an incredible relief for people that may be facing fees in order to be able to not have this be another weight added to their financial pressure. And also, if I may add, if BBP and AFP are on the same side, it might be worth considering. So thank you.
Thank you for that. Well, we did have a concurring from the public defenders and the district attorney, so I guess we're just at that day right now. Is there anyone else in Carson City that would like to come forward with support?
Patricia Malinkov Ackerman here. That's Patricia Melynkov. Ackerman, Ackerman. I thank Madam Chair for bringing this bill forward. I am very grateful to Assembly Member Orentlicker for bringing this forward. I think that you all can see we have an individual whose life is being threatened, and she is falling through the cracks. It was very emotional for me to listen to this testimony, because she is a friend. I urge you all to do the right thing. Protect a life. Thank you.
Thank you so much. And I just want to make one correction. This is actually Assemblyman Orentlicker's bill. So he's the sponsor. Thank you. I just schedule it. So thank you for that. But I want to make sure that's correct on the record and that he gets his credit. So anyone else here in Carson City to testify in support? All right, not seeing anyone. Is there anyone in Las Vegas that would like to testify in support? Broadcasting, will you open the lines, please?
To testify in support of Assembly Bill, I'm sorry, I forgot.
369. I know I have to look multiple times during the
369.
hearing as well.
To testify in support of Assembly Bill 369, please press star 9 now to take your place in the queue.
Good morning. On the right bill this time. Good morning, Chair, members of the committee. My name is Jody Hocking. While I'm usually here in my capacity as the Executive Director of Return Strong, today I'm also here as a woman who was a single parent, raising my children alone. We were a family who lived on the bubble of poverty. I worked and made approximately $21,000 a year at that time. That was the cutoff for most types of assistance, so while I received some assistance with childcare, we didn't receive food stamps or medical care. I want you to understand that during those years, we lived in survival mode, and I made a lot of decisions that were solely about surviving at that time. I drove illegally for many years with a suspended or expired registration and no driver's license. During one particularly difficult period with my back against the wall, I wrote a check for groceries that I knew was bad. We'd run out of everything, even the backups that filled their hunger but not nutrition. The kids were asking for things to eat and I didn't have anything. Absolutely nothing was left. We'd already accessed the food pantry and I had nowhere left to go, and I wrote a bad check for groceries. Soon after, the check and the car landed me in court. Following that, I was caught in a cycle that's really difficult to explain as you're trying to dig yourself out of a hole. But I was still trying to live on $21,000 a year and find a way to work because I didn't have a car anymore. My job was 40 minutes away. It was my only choice. I already struggled to keep food on the table, but now I also had to pay the fees associated with the check and the vehicle issues. I remember going back to court for extension after extension after extension, taking time off work, which put us further in the hole. Well, my daughter, who's now a social worker, talks about those years and about those struggles. And in general, for all people, she often says that people don't always make good choices, they have good choices. AB 369 gives people a chance at making better choices. It levels the playing field just a little bit, and sometimes people don't need the carrot or the stick, they just need a fair opportunity. Return Strong works with so many families who are surviving with their back against the wall, living on one income while supporting an incarcerated loved one, and we just want to thank everybody who was part of making this happen. We're in support of AB 369. And hope that you move this forward, and it goes into statute. And thank you for everything.
Thank you so much. Next caller.
There are no other callers at this time.
Okay, thank you. Then I will open it up for opposition, starting here in Carson City.
Good morning, Chair Miller and members of the committee. My name is Jeff Rogan, representing Clark County, and I'm here today on behalf of the Justice Courts of Clark County with some opposition to this bill as drafted. I'd like to just point out that we only had a brief moment to discuss this bill with the Fines and Fees Justice Center this morning, and they are agreeable to meeting with us to address the concerns I'm about to discuss with you. Turning to the bill itself, I'd like to begin by pointing out that existing law already provides an indigent person two remedies if they're unable to pay a fine or fee or an assessment. First, as you heard today, when a person is ordered to pay a fine and the assessments by a Clark County Justice Court, they're offered the opportunity to complete community service if they can't afford those fines, fees, and assessments. The existing law is NRS 176.087. But also, if a person can't afford a fine, fee, or assessment, the court has the option under a different statute, that's NRS 176.085, to reduce the amount due upon a finding that the fines, fees, and assessments are excessive in relation to the financial resources of the defendant. Again, this is already existing law. And we're unaware of any concern that's been raised as to why these two statutes don't address the issues that have been brought forward to you today. Our next concern has to do with the operational impacts of this bill, particularly sections 2 through 5. As I mentioned, existing statutes allows a court to reduce a fine, fee, and assessment based upon the circumstances of the defendant. This finding is not conditioned upon any strict calculation of indigency, as this bill proposes, but upon a review of the whole person, and that is all of the relevant facts and circumstances of a defendant's life that would justify a reduction. The proposed bill instead requires the court to use these specific guidelines under the Home Investment Partnerships Act. The technical guide for calculating income under this standard is 139 pages long. As suggested by one of the presenters, the court and the staff would need to review the information provided of every defendant before assessing a fine. I'd point out that this would require our courts to review the eligibility of tens of thousands of defendants every year. To review this paperwork, verify the accuracy of the information, and assess the ability to pay of every defendant under these guidelines, the Las Vegas Justice Court alone would require an additional 14 full-time employees. And as all of this could not be done at the time of arraignment, when most cases, criminal and traffic, are resolved, we would require additional court dates to effectuate the purposes of this bill. Lastly, we have several concerns regarding some other particular provisions of the bill that are undefined, as Mr. Shepak mentioned. It's not apparent to us or our courts as to how a person can complete remote community service, for example, and also the definitions of some of the community service under the last section of the bill are unclear, such as what is meant by public service or work on public projects. And our courts will need clarity on that to ensure that the defendants are completing appropriate community service. Again, I want to thank the bill sponsor and the Fines and Fees Justice Center for their willingness to work with us to address these concerns, and I look forward to meeting with them. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. I first want to thank the Assemblyman for being very gracious with his time. I was able to speak with him briefly last evening, and also the stakeholders. I spoke with them very briefly this morning as well, and we look forward to continued conversations on this bill. And I also want to acknowledge the UNLV students. It's great to see them involved in the legislative process. However, the city is opposed to AB 369 as drafted. We are opposed to the bill for several reasons, but in particular the use of the 139-page Home Investment Partnership Act to calculate household income, believing this may require a large amount of staff time to assess a person's ability to pay. Secondly, changing the requirements for the supervising authority for community service. We believe this adds complexity to a system that is already in existence. And lastly, the conflicts with current NRS. For example, the bill would decrease the number of years courts have to collect a fine or fee from 10 years to 5 years on all offenses handled by our courts. And we just want to note that the legislature recently increased the number of years from 8 to 10 years in 2021 in AB 116. And then we also want to point out the conflict with domestic battery mandates. For example, the statute regarding domestic battery mandates that the convicted individual be sentenced to include for a first-time offense perform not less than 48 hours, but not more than 120 hours of community service, and for a second offense perform not less than 100 hours, but not more than 200 hours of community service. This is in NRS 200.485, and we believe that conflicts with part of the bill as well. So we look forward to working with the Assemblyman further and the stakeholders, and but we are opposed to the bill as drafted today.
Good morning, Madam Chair. Pleasure to be here for a second time today in Assembly Judiciary. I'd like you to know that I paid very good attention on the first meeting that we had when you gave us instruction. The instruction was that we love a good Me Too comment here in Assembly Judiciary. So just want to agree with my colleagues from Clark County and Henderson. We share the same concerns. We are very appreciative of the Assemblyman, his willingness to work with us going forward. So here right now in opposition, but look forward to continuing the conversation. Thank you.
Thank you so much, and I appreciate that. And I also really appreciate the irony of the longest Me Too comment that we've ever heard. Thank you so much. Is there anyone else here in Carson City in opposition? Okay, not seeing any. Is there anyone in Las Vegas? Broadcasting, will you open the lines, please?
There are no callers at this time.
Thank you. Anyone in neutral? If there's anyone here in Carson City that's in neutral. Is there anyone in Las Vegas in neutral? Broadcasting, is there anyone that's on the line in neutral?
There are no callers at this time.
Okay, thank you. Assemblyman, would you like to make some final remarks?
Thank you, Chair. David Ornlicker for the record. As you can see, this was a real team effort. I'm grateful for the help of Nick Shepak and Lisa Mosley at the Fines and Fees Justice Center, my co-sponsor, Assemblywoman Cecilia Gonzalez, and especially this faculty, Professor Eve Hanan, and the students, Shaylin Dieter and Ryan Edwards at UNLV Boyd School of Law. So thanks to everybody. Thank you for hearing this. We are planning to work with the officials who spoke. I think we can address some of their concerns by going through the California experience and the other studies in this area. And other things, we do anticipate making some changes because there are some areas that need clarification. So we look forward to working those things out and coming back to you with a bill that everybody is comfortable with.
Lisa Mosley Sales. I want to stress, first of all, thanks again to the Assemblyman and all of the gratitude that he expressed to everyone, including the committee and members. But I want to stress that this is a compliance and accountability bill. And I don't think there's anyone in this room, in support or opposition, who doesn't want to see people held accountable for our actions. So this bill, above all, is a compliance bill. And though there are already in statute remedies for courts, for defendants, community service, and also reduction of fines, what we have found is that those remedies are not always applied. They're not always applied. And though someone can ask for reduction or do community service, what this bill does is allow for an ability to pay assessment, which takes into account, as Mr. Rogan stated, someone's circumstances, their income, the number of dependents that they have in their house. And though that's in statute, I believe, according to Mr. Rogan, it's not always applied. Our students at the law school observed, we have been doing court observation for some time, and what we have found is that in most cases, the judges do not offer that. They do not take that into consideration. They offer a payment plan. What this bill does with an ability to pay is it scales the fine. And so what we have seen is when the defendants are given a blanket fine across the same fine, it reduces the accountability and it reduces compliance. But when someone has a fine that is proportionate to their ability to pay it, it increases the compliance. We referenced a report out of California that is in your exhibit. It's there. And what California found is well over almost a 70% compliance rate. And by compliance, what they mean is those fines were paid in full. Well over a 70% compliance rate when people's ability to pay is taken into consideration and the fines are reduced according to what their income is. In reference to using the home standard, we are simply using the income guidelines. We're not asking courts to review 100 and some pages of documents to assess someone's ability to pay. We're simply using those income guidelines. Someone mentioned domestic violence. 2 points. One is anecdotal and one is going to be evidence-based. I have experienced domestic violence. Many of you who know me on this committee and know me in this room know that I left an unhealthy marriage for that very reason. I'm very sensitive to that. I have also served on the Attorney General's Committee for Domestic Violence, formerly known as the Nevada Council for the Prevention of Domestic Violence, since 2012. What we have found is with perpetrators of domestic violence, particularly in the rurals. And I'm speaking to this more as a personal comment and someone who serves on that council, rather than in my capacity as the state director for the Fines and Fees Justice Center. In particularly rural counties, what we have found is because community service options are so few, and those communities experience higher levels of unemployment and poverty, what we often see with compliance around their programs and around the community service is lower. We are totally amenable to adjusting or carving out some of the concerns about community service for perpetrators of domestic violence. But if we want compliance and if we want accountability, then we will make it so that that population can comply as well. We're not asking for complete reduction. We're not asking for any of that. And also I want to point out that courts still have the ability to do what courts will need to do. They have the ability to order the minimum amount or maximum amount of community service. We're not asking to change that. This is simply asking to remove any of the additional barriers that we have seen and that our data supports that reduce compliance. With these barriers removed, you all can just look at your reports that we have submitted, look at the data. What it shows is that when we take these things into consideration, compliance rates and accountability increase. So with that, I want to again say thank you to the committee. We are totally amenable to working with all of the stakeholders, including community members that are stakeholders. I am grateful actually for the opposition because in my opinion, opposition breeds dialogue. It's an opportunity to discuss everyone's positions and take those things into account. And I am confident that when we do that, we will come up with a bill that works for everybody. And we will be able to hold people accountable for their actions, and we will increase compliance. So with that, I say thank you.
Thank you so much for that. And again, appreciate the willingness to continue working on this legislation. I don't want to put time limits on anyone, but we all know kind of where we are in session and we just have a few weeks. So I anticipate this work will happen quickly. Thank you for that, and I will go ahead and close the hearing on Assembly Bill 369. And with that, our last order of business for the day is public comment. So if there's anyone here in Carson City that would like to make public comment, again, this isn't commenting on the bills we heard today, but on anything else under the purview of this committee. Not seeing anyone come forward. I don't believe there's anyone in Las Vegas. Broadcasting, will you please open the lines for anyone wishing to make public comment?
The public line is open and working, and there are no callers at this time.
Okay, thank you for that. Then with that, I will go ahead and adjourn, and we'll see everyone back at 8 a.m. tomorrow morning. This meeting is adjourned.